All right, now, Mr. King, has the alleged victim or victims of this offense, these offenses been notified of the time, place, and purpose of this hearing, the opportunity to be heard?
Yes, Your Honor, both victims have been notified, and neither victim is present today.
All right, thank you. All right, now, Mr. Gilroy, this document says you're going to withdraw your not guilty plea and plead guilty to both counts which charge you with domestic violence under 2919.25A of the Higher Revised Code, a third-degree felony. Further states that you understand the possible prison term for each of those offenses could be between 9 and 36 months. There are certain levels in between those two ranges. It goes from 9 to 12 and then 18 and then every 6 months up to 36. There's also a fine available of $10,000. In the event that you were sentenced to the maximum sentence on both cases, both counts, I should say, that would be 36 or 72 months or 6 years and a total fine of $20,000. Do you understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on community control, probation, parole, or post-release control for a felony?
No, Your Honor.
Right, under the law, Mr. Gilroy, if you are sentenced to prison for these offenses, once you complete your prison term, the law provides that you will be placed under post-release control supervision by the Adult Parole Authority for a period of at least 1 year and a maximum of 3 years. And you'll be supervised by a parole officer. And the APA, or Adult Parole Authority, is the one that sets those conditions. If during the period of time you're being supervised, they determine that you have not complied with those conditions, they can return you to prison to make you serve an additional period beyond that ordered by the judge of up to 9 months for a single violation, but there is a cap or limit of half of whatever prison term was imposed for all violations. But should you be convicted of a new felony under post-release control, then in addition to whatever sentence the judge in the new case can impose upon you, the judge could also sentence you for committing that violation while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater, and if that occurs, that has to be served consecutively to the new sentence. Do you understand that?
Yes, Your Honor.
Now, under the law, this is not a mandatory prison offense, and so the court could grant you community control. There is and so that could be for a period of up to 5 years, and the terms would be set by the court, and you'd be supervised by a probation officer. If during that period of time they felt that you were non-compliant, then they would file a notice of that with the court in writing. You would get a copy. There would be a hearing. If the outcome of the hearing was that you failed to comply, then at that time you could have your community control revoked and then be sentenced to the 72 months and fined $20,000. Do you understand that?
Yes, Your Honor.
All right, now, the charges in this case allege in count 1 that on or about May 17, 2023 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to V1, a family or household member, having previously been convicted of 2 or more offensive domestic violence in Auglaize County, case number 2012 CRB 00365 on June 25, 2012, and Allen County, case number CR 20130474 on April 24, 2014. So that would be a violation of section 2919.25A of the Higher Revised Code. Count 2 is identical except it alleges a different victim, V2. Now, Mr. Gilroy, do you understand what it is you've been charged with, having done what the state said you did, when, where, and how they allege that you did it? Have you discussed the nature of that charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
And are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No.
Now, on page 3 or 2, there are 3 sentences that are printed in bold and underlined, which I'll read as follows. Defendant will enter a plea of guilty to the indictment. State and defense jointly recommend 12 months incarceration on count 1, consecutive 12 months incarceration on count 2. State will not oppose judicial release treatment after 12 months. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though this is the recommendation from the state and your attorney and you that the sentence be 12 months, of course not required on each count, of course not required to follow that. If you plead guilty, I can impose any sentence that I think is appropriate between 9 and 36 months on each count consecutive. So that could be totally possible 72 months. You understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any trade, occupation, or profession?
No.
Right, now you have certain constitutional rights you must understand before I can accept a plea. First of all, you have a right to have an attorney, and if you do not have the funds to hire one, one will be appointed. So Mr. Kirk was appointed to represent you. Now that wasn't simply to work the case out, but to provide whatever defense might be available to you under the law that you'd like him to provide. So if you decide you don't want to do this, you'll still be represented by counsel. He'll defend you, and that would include a trial if that's what you want. Do you understand that?
Yes, Your Honor.
All right, now, under the law, you have a right to have a jury trial on these charges, which means that a jury of 12 people would be selected from a group of citizens that live in this county that would be summoned for jury duty on your trial date. After they are selected, the evidence would be presented. They'd be instructed on the law by the court, and then they would decide by unanimous verdict, meaning all 12 would have to agree on each count, as to whether the state proved your guilt. Now, if you decided you didn't want to plead guilty, but you didn't want to have a jury trial, you can have instead what's called a court or bench trial, which means that after you sign a waiver in writing of your right to a jury trial, you would then have the trial to the court or the judge. The judge would be the one to hear the evidence, apply the law, and decide whether or not the state proved your guilt on either or both counts. Do you understand that?
Yes, Your
All right, now under the Constitution and the law, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. What that means is that the witnesses against you have to come into the courtroom and testify in person in front of you and your attorney and anyone else who may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Honor. Yes, Your Honor.
Now, under the Constitution, Mr. Gilroy, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, Your Honor.
All right, now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to talk about it except in one situation. If there's a jury trial and the judge, and you decide not to testify, then the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the law, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty of these charges simply because you've been accused. In fact, under the law, you're not required to present any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty to these charges, which denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that there are crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you, except your right to have a jury trial. You always have a right to have a jury trial, no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. It waives, gives up your right to confront the witnesses in open court and to cross-examine through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf. And waives, gives up your privilege against self-incrimination because you say you're guilty, that's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you guilty. Now, it doesn't waive, as I said, it doesn't waive the right to have an attorney, but it waives all of the rest of those rights. Now, it also waives your right to file an appeal on any alleged violations of your rights you feel have occurred up to this point in the case. Now, if I should sentence you to the maximum sentence or in other limited circumstances, an appeal could be filed. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right. And again, I don't think I said it, but it does also subject you to being sentenced immediately by the court, which I think is what's being recommended here. You understand that?
Yes, sir.
Okay. And did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
Now, is there, you have any questions about the charges, the possible penalties?
No,
You understand?
yeah, I do.
Have any questions about the plea agreement?
No,
You understand it?
yes, I do.
And you understand that the recommendation as to sentencing is not binding on the court?
Yes, sir.
Now, do you have any questions about the constitutional rights I've explained?
No, I do not.
You understand those?
Yes, I do.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
Yes, sir.
You have any questions first?
No, I don't.
Okay, so you do understand them?
Yes, I do.
Okay. Now, is there anything you need to speak with your attorney about before we go any further?
No,
All right, you have any questions at all about anything that I've explained today or anything that is in the plea agreement?
I don't believe I do.
Then is it your decision to withdraw your not guilty plea, plead guilty to these two counts pursuant to the terms of the written plea agreement?
Yes, sir.
All right, then as to the charge, which alleges in count 1 that on or about May 17, 2023 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to V1, a family or household member, having previously been convicted of 2 or more offenses of domestic violence in Auglaize County, case number 2012 CRB 00365 on June 25, 2012, and Allen County, case number CR 20130474 on April 24, 2014, in violation of section 2919.25A of the Ohio Revised Code, the offense of domestic violence, a third-degree felony carrying a possible prison term between 9 and 36 months, and a fine of $10,000. How do you plead?
Guilty, Your Honor.
And as to count 2, which alleges the same offense, the same time and place, except against a different person, V2, how do you plead?
Guilty, Your Honor.
All right, thank you. All right, the court finds that on this day in open court, the defendant was advised of all of his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted, ordered, filed. Defendant is found guilty of each of the offenses as charged. Now, given that this is not the defendant's first convictions for these offenses and the agreement that there should be a recommended prison term imposed, the court is not going to order a pre-sentence investigation, and instead I will proceed with sentencing. Mr. King, on behalf of the state.
Thank you, Your Honor. The state would ask that the court follow the joint recommendation. The state has consulted with the victims in this case, and both victims have approved of this agreement. That's all, Your Honor.
Mr. Kirk?
Thank you, Your Honor. Obviously, this is a situation where had he not had priors, would have been misdemeanors. So luckily, the behavior here was such that nobody was taken to the hospital or anything of that nature, but it was still obviously a physical assault type situation. Of the 2 victims, one of the victims is a male. He has contacted my office, very adamant that my client received help. And then in speaking with the prosecutor's office, obviously the other victim was a female, wanted some form of punishment and was okay with a year in prison. So the plea offer is certainly something that would accomplish both, provided that he is, released at some point to get some help. He could certainly be punished first and then get some assistance with his issues by going to STAR or whatever other help might be available at that time. So we hope that the court would agree to the plea agreement. I've explained to him there's no promise of judicial release. It's going to be up to the court at the time the application is filed. If how that goes, but he understands that. But would ask the court to follow the plea agreement.
All right, Mr. Gilroy, is there anything you'd like to say?
No, Your Honor.
Are these victims of these offenses have they been victims of any of the previous offenses?
Not to my knowledge, Your Honor.
Okay. Well, I'm looking here at the record, Mr. Gilroy. It looks like in 2000, according to the discovery compliance from the state, you were originally convicted in 2005 on 2 counts of domestic violence, 4th-degree felonies, and received probation in Allen County. And in 2009, you were convicted of domestic violence, received 6 months in Cuyahoga County. 2012, a conviction in Auglaize County for a misdemeanor, 180 days in jail. 2013, conviction in Allen County, that was 18 months incarceration. 2021, an assault in Highland County, 2 years probation and anger management. 2022, assault in Clinton County, 180 days jail suspended. So that's a very disturbing record, Mr. Gilroy. The fact that it's widespread, it's not unique to any particular county, doesn't seem to be unique to any particular individual. It just seems to be that you like to beat on people, and that's very disturbing. Now, obviously, you do have an issue, but I see here that you had probation once, and 18 years ago, you had probation in 2021. We're supposed to get anger management in Highland County. And it just seems that, you seem to be just enjoy beating on people. And so if you want help, that's up to you. You have to make some decision. I would think that having, and I also see that when you were a juvenile, you had an assault in Allen County and got probation and treatment. So my concern is for the safety of the public. I would like to see you get help, but on the other hand, it seems like you've had some opportunities and you haven't utilized that. And it's not up to the court and treatment providers and probation department and so forth to give you, to help you. They can't do that. They can offer you some tools, but you have to make that decision. And it seems to me clearly that you've had that opportunity in the past, but have not utilized it. And I have some serious reservations. Given your record, I think 12 months is way too low for a sentence. I'm going to take into consideration the fact that you have admitted your guilt and not required a trial in this case. But I'm not going to follow the plea recommendation. 12 months is just not sufficient. I will be open to considering judicial release, but I'm going to have to be convinced at that time that you're serious about changing and not just wanting to not go to prison again or to get out of prison again. So it is the judgment and order of the court that you be sentenced to 24 months at the Correction Reception Center, Orion, Ohio, on each count. Those sentences are order runs consecutively to one another for a total of 48 months. Need jail time credit. Now, as I've just discussed, the first and foremost that the court takes into consideration is this is what's necessary because your history to protect the public. You have an extensive history of violence, one of the worst that I've seen in terms of being a domestic abuser and just assaulting people. Secondly, these offenses are committed against 2 different people, part of one course of conduct, but one single prison sentence is not sufficient to reflect the seriousness of the offense. And the 24 months, while more than what was recommended, is still only about 2/3 of the maximum sentence that could have been imposed. And so it's not disproportionate to the harm that's been caused or the danger that you pose to the public. Now, we don't have jail time credit on this case. All right, so May the 17th was the arrest date, is that correct, counsel?
Yes, Your Honor.
Yeah, I believe he was arrested the date of the incident. So
All right.
yes.
So that would be 14 days in May, 30 in June is 44, and 21 is 65. So you have 65 days of credit against that sentence, Mr. Gilroy. Now, and again, I'm not promising to grant you judicial release. Quite honestly, I doubt that I'll grant it after a year, so if you want judicial release, I suggest you might wait till between 18 and 24 months before you file for that, because you only get one chance unless the court allows a second chance, and that's not very often. But upon completion of the prison term, if you serve the entire term, it is mandatory you be supervised by the Adult Parole Authority for a period of at least 1 year and up to 3 years under post-release control. And if during that period of time the APA, Adult Parole Authority, determines that you've not complied, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to half of your prison term, or 24 months for all violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence a judge in that new case can impose, that judge can also sentence you for committing that crime while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentence in the new case. Now, you're also ordered to pay the court costs which judgment, grant, execution is ordered, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, you can be permitted to do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded back to custody, Mr. Gilroy. Thank you. Okay, this is case number 2306, CR 133, 23 CR 133, State versus Daniel Levi Butcher. You're Daniel Levi Butcher?
Yes, Your Honor.
All right, Mr. Butcher, you were indicted by the grand jury on July 11th on a single count of possession of drugs, which is alleged to have occurred on or about November 29, 2022 in this county. Alleges that you did on that date knowingly obtain, possess, or use a Schedule III controlled substance, to wit, buprenorphine, and that you had previously been convicted of a drug abuse offense, to wit, trafficking in heroin in the vicinity of a school zone in violation of Section 2925, 2003A1, a felony of 4th degree in Highland County Common Pleas Court. So that would be a violation of Ohio Revised Code Section 2925.11, which is a 5th degree felony, which carries a possible prison term convicted of between 6 and 12 months, fine of $2,500, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have counsel to represent you in this matter, and if you do not have the funds to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form, and you're at the counseling center, correct?
Yes.
Everything on this form is correct, Mr. Butcher?
Yes, sir.
All right, the court will find you qualified for appointed counsel. Appoint Attorney Sarah Barger of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. The court will set a pretrial for you. It'll be by Zoom on August 16, and that'll be at 2:15 p.m. Set your final pretrial for September 6th at 2 o'clock p.m., also by Zoom. And the trial date will be set. That'll be an in-person trial date of September 25th at 8 a.m. And release you on your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony. You'll be under the same conditions that you were previously. I know you're in the drug court docket, so you'll just need to report to the probation department as soon as you're released. Actually, as soon as you're released, you can come up to court for the drug court docket, and then can talk to probation then at that time. And then the same conditions will apply as previously. You report as they directed, undergo random drug testing, provide phone numbers for home, cell, employer, and a special condition is that you comply with the counseling center SUD residential treatment and aftercare. All right, we'll notify Miss Barber of her appointment, and she'll be in touch with you. We'll have we'll notify you, or your case manager, of the Zoom link for your pre-trials. You have any questions?